So that leaves us to our presentation on wage and hour compliance with attorney Jacqueline Fogg. So Jacqueline is an attorney with Schwartz, Hannum, PC, and a member of the firm's labor and employment and education practice groups. She counsels a variety of clients, including corporate businesses, nonprofit organizations, and independent educational institutions on all aspects of employer-employee relationship. Jacqueline has extensive experience representing and counseling multi-state clients with respect to state-specific issues. As part of her practice, Jacqueline regularly advises clients on implementing practices and policies for compliance with federal and state labor and employment laws, as well as best practices for each client's specific industry. These areas include conducting interviews, hiring and onboarding, reference and background checks, employee classifications, employee performance, improvement plans and management, leaves of absence, and accommodations requests, employment terminations, reductions in force, and separation and severance agreements. That's a lot of stuff. And that's why we have you here today. Jacqueline also counsels clients in matters involving employment discrimination, wage and hour issues, harassment claims, investigations, and crisis management. She also represents businesses, nonprofit organizations, and educational institutions against alleged violations of state and federal discrimination laws, wage and hours claims, wrongful termination claims, and breach of contract claims. Jacqueline works closely with clients to develop and update fundamental organizational documents such as handbooks, applications, employment agreements, and offer letters, background checks, forms, job descriptions, and leave and accommodation forms. She partners with clients to ensure that such documents comply with applicable law and best practice while accurately reflecting the organization's business and culture. Jacqueline also handles numerous student-focused matters for independent schools and other educational institutions. In this area, she routinely advises these clients on admissions applications and processes, enrollment agreements, disciplinary issues, child abuse and neglect reporting, health and safety practices, and risk management for off-campus trips. Jacqueline is a frequent presenter on labor and employment law issues. She is a graduate of the Massachusetts School of Law and Suffolk University and was selected as a Massachusetts Super Lawyer Rising Star 2019 to 2022 as a member of the American Bar Association, Boston Bar Association, and the National Association of Women Lawyers. So, Jacqueline, take it away.
Thank you, Jonathan, and thank you, MassAccess, for having me here. I'm very excited. I want to preface by apologizing for my voice. I have two little ones that bring all their germs home from daycare, so I'm on the tail end of bronchitis, so I do apologize. On antibiotics, so I'm fine. Jonathan did a great job of, explaining what I do in my practice. I work for Schwartz Hannum. I have been with the firm for about 7 years now. We are management side employment lawyers, so I work daily with HR people, directors, executive directors of offices, and counseling them to make sure that they're acting in compliance with the law in their business's best interest at heart. We run the gamut of all the things from the hiring to the firing and everything in between. Today we're going to focus on wage and hour compliance. There's a lot of information in the presentation, and I have left some folders out on the front that has a copy of the presentation and some information about our firm, so make sure you grab one of those if you haven't already. But with my presentations, please, I like to be a little bit more informal, so please feel free to interrupt me at any time, ask questions, let me know if you can't hear me or understand me. I tend to talk fast as well, so please feel free to interrupt me at any time. Then we'll get started. So I'll stand in front of the mic though. So our agenda today, we're going to cover the two major laws that apply with wage and hour compliance. You have the Federal Fair Labor Standards Act and the Massachusetts Wage Act. I'm going to touch on some major compliance issues that we see, as well as some updates, things that have occurred this year and that are coming down the line for you to be aware of. The first law is the Federal Fair Labor Standards Act. We call that the FLSA. This sets the groundwork for what employers need to do. It regulates certain areas of wage and hours, such as minimum wage, overtime pay, record-keeping requirements, equal pay, child labor, break time for nursing mothers, and exemptions from minimum wage and overtime. Most recently, there was a new law passed called the Pump Act, which now requires everyone to provide nursing time for mothers, reasonable break time, as well as a private location where they can express breast milk in the workplace. So that just went into effect this year, so something to be mindful of. Massachusetts Wage Act also covers minimum wage and overtime, payment of wages, deductions from pay, meal and rest breaks, earned sick time, record keeping, notice requirements, equal pay, and child labor. Many areas of mass law, we follow the FLSA, but in more often than not, Massachusetts tends to be more generous than the FLSA is. So like I said, kind of think of the federal law as that groundwork, and state law may be a little bit more generous or provide, more options. So the perfect example is minimum wage. Federal law, it is still at $7.25. Massachusetts, we're now up to $15 an hour. You may have been familiar with the Grand Bargain that was passed years ago by Governor Baker, which instituted, raising the minimum wage up to 15 in increments over the years. We are at that 15, so there's no more increases coming under that law unless they decide to increase the minimum wage again, but we'll see. And just know that this may not apply to you, but special minimum wage rates apply to different types of employees. So tipped employees, there's a different wage, as well as agricultural employees. Overtime. So non-exempt employees, and we're going to get into talking about exempt and non-exempt employees and what that actually means. But your non-exempt employees who work more than 40 hours in any work week must be paid overtime. Overtime pay has to be at least 1.5 times the employee's regular rate of pay for each hour actually worked over 40. So the actually worked is really important because the hours don't include, any paid time off they take, any holidays that are given. So they have to actually work those hours to get that overtime rate. And a big point that most employers don't realize is you can't award comp time instead of paying overtime. So even if an employee asks you, well, can I just take this day off next month instead of doing this? No, it's not allowed under either mass or federal law, so you have to pay them that overtime. Proper employee classification.
What about salaried employees?
For the overtime? Yeah. So I'll get into this distinction because it is a big area of confusion. So there are certain exemptions for minimum wage and overtime requirements. Both laws provide them. Massachusetts generally follows the FLSA, but does have, some additional exceptions that apply. But the important thing to remember, and this is good to Jonathan's point of the salaried, many people just refer to employees as salaried or hourly. And that is the incorrect way to kind of classify them. You want to classify them as exempt or non-exempt. Exempt means that you aren't required to pay them minimum wage and overtime. Non-exempt, you do. You have to follow the laws and the requirements. So for an exemption to apply, there's specific job duties that must be met and salary basis tests, which we're going to talk about more. So for non-exempt employees, like I said, they must be paid minimum wage and overtime. So the biggest confusion here usually is that non-exempt employees can be paid either on an hourly basis or a salary basis. So so therefore they may be eligible for overtime. If they are paid on a salary basis and work over 40 hours in a week, what you have to do is break that weekly salary down to figure out what their hourly rate is to pay them that overtime. So this is one of the biggest issues that employers come up with, is that they think that just because they're salaried, they're not eligible for overtime or entitled to that overtime pay. So it's really, really important to make sure our employees are properly classified. And we'll get into that a little bit more. Yeah.
So what is a salary? It's just not like salary is just another term for calling an hourly person. Oh, I'm sorry. So a salaried person, it's a non-term?
So it's not, yes, so you can, more often than not, your non-exempt employees are going to be paid on an hourly basis. But sometimes employees like that salary, to look at that salary, they provide them, this is your annualized salary, rather than breaking it down, this is your hourly rate. So the method of being paid doesn't matter unless the focus is more on that exempt or non-exempt classification. So for non-exempt, they can be paid either way. Exempt has to be on a salary basis. So and this is the thing when counseling clients, people go, well, they're salaried. Well, that doesn't mean anything to me. You know, that to me as an employee, I don't care. So, you know, what are their job duties? What do they do? Things like that. That's what's going to make them whether they're exempt or non-exempt. So that is your important classification there, not classifying them as salary. Salary is just something that people have typically used as another term for exempt. And that's the common misconception, is that non-exempt employees aren't paid on a salary basis. They can be. It's all in how you present it. I recommend, you know, offer letters, things like that. If you have a non-exempt employee, put their hourly rate in there, and you can say, you know, which will be an annualized salary of this amount. But some people just say, this is your annualized salary, and then just assume that they're exempt, but they may not be, because it all comes down to those tests under the FLSA and Mass Law with their job duties, which we're going to talk about. Does that make sense, Ron?
Yeah.
So in addition, you know, there's additional requirements under both federal and state laws. So you want your non-exempt employees to be tracking all of their hours. So making sure whether they do timesheets, time clocks, if it's electronic, it's really important to have those time records, because then you can clearly see whether they are due overtime or not. And whether they're working, you know, their right scheduled hours. So the timesheet should really track when did they start their day, when are their lunch breaks, when they come back from lunch, and when are they leaving for the day. Also, any time off that they may take, because as I said, it's important that you know what days are what, because certain holidays and time off will not count towards overtime hours. So one thing I did mention, you can't have comp time. What you can do is adjust a schedule in the same payroll week. So if an employee happens to work, you know, 2 extra hours one night, you could have them come in 2 hours late the next day. So the only time any adjustment in like their daily scheduled hours can be, it has to be in that same payroll week. So you can't do, okay, you know, worked all these extra hours this week, you have an extra day off in 2 months. That's a violation of the law. But if we're in the same payroll week, we can adjust this schedule. Yeah.
What if it's the same pay period?
Just so we're recording everyone.
Oh, right, yeah.
I'm sorry.
I'm the one. I'm the Mike Ferry too. Anyways, what if it's the same pay period?
It's by the week.
It's by the week.
Yep, so even if you do, you know, biweekly period, it's that 40 hours is that mark. So you want to look at the week, because if they work over 40 hours in a week, then it's, we're talking about the adjustment.
Because I'm a non-exempt employee, and sometimes my hours fluctuate.
Yep,
So sometimes I go over my 37.5, and then I take some time off the next week.
the next week.
So if it's in that same pay period,
Yes, that's okay.
that's okay. Okay.
Yeah, that's okay.
Okay, cool.
Any other questions on non-exempt before we move to exempt? I mean, we'll keep talking about both of them, but for exempt, there are, you know, certain tests that you have to satisfy. Like I said, Massachusetts generally mirrors the FLSA. So the duty there, and it has the same test. So it's the duties test, the salary basis test, and the salary level test. So for the duties, they have to primarily perform bona fide executive, administrator, or professional duties. The FLSA has very detailed tests of what that means. So what they're called is the white collar exemptions. So basically, you know, the executive exemption is if somebody, you know, manages the business, is in charge of like the financials, has independent judgment and discretion to make significant decisions for the business. You know, also if they supervise 2 or more employees. There's things like that. Administrative, again, you know, office work, is in charge, has that independent discretion and judgment, is in charge of important matters for the organization, does not, you know, they don't have to, manage employees. Professional duties is Me. I fall under a professional exemption because I'm a lawyer, so I have advanced knowledge in an area. Teachers also fall in this category. So science, professors, things like that. Anyone who has an advanced knowledge in education and has to have a certain degree to be in that field will qualify under the professional exemption. So the presumption is if they've spent 50% of their or more of their time on these duties, then they meet the qualifications for the exemption. Salary basis, so exempt employees have to be paid on a salary, and it has to be the same amount regardless of how many hours worked. And the salary level has to be at least $684 a week right now. I have it later on in the slide, but the Department of Labor has proposed a rule to increase that amount, which would open up a lot more employees being classified as non-exempt than exempt, but I'll get into those details later. They've tried it a few times, so it's likely that it may pass next year.
So you're saying the 684 is gross, not take home?
Correct.
Thank you.
Yeah. There's also a highly compensated exemption, so the total compensation of at least $107,432 per year. They do still have to do some of the, duties, but it's not as specific as these other tests. There are other state-specific exemptions that apply. Seasonal employees is a big one. There's a whole list that Massachusetts has outside of here, but none of them really, I think, apply to you guys. And I found my first typo, and I'm very embarrassed by this, so I do apologize. So it should be, she agreed to be a salary employee. So I have these hypotheticals, which are actually real-life cases that we've dealt with, and this is a recent one that I had with a client. So Vision TV hired Lily as an office manager. During the hiring process, Vision told her she would be paid on a salary basis and expected to work at least 42 hours per week. Vision never had Lily fill out timesheets and didn't pay her overtime during her employment. After Lily resigned from her employment with Vision, Vision received a letter from Lily's attorney demanding $75,000 in unpaid overtime wages. What, if anything, did Vision do wrong? Sorry, I didn't realize we'd have to be on my...
Well, I'll leave the expertise to you, but it seems that the first thing I realized is it's got right there 42 hours, and that seems like a red flag for discrepancy.
Yep.
Was she exempt or non-exempt?
They didn't say, did they?
No.
Yeah.
Yeah, no.
And no
records.
timesheets?
All
Good job.
right, yeah.
So that's perfect. You picked up the major thing. So this is a case I had with a small employer, and they called me up and they said, well, she agreed to be salaried. And I said, well, what are the job duties? What is this? And so they thought it was just salaried and hourly, and so had him classified. It was a guy, sorry, that's why I put he. I tried to change it and cover things up, but I'm gonna keep saying, not good at this. But, so they just classified him, okay, he's salary, he gets the salary, and that's that. But he worked over 40 hours the majority of the time he was working there, and it was right in the offer that he was expected to work that time. So they were very angry that this happened, but it was a wage violation. So what my recommendation was, we need to settle this, because the Massachusetts wage law, in fact, is very strict on wage violations, and so they could have been on the hook for treble damages, so 3 times this amount. They never had him do timesheets or anything, so he had kept timesheets on his own and said, this is how much you owe, and we had nothing to refute that. So the big thing is any lawyer will tell you, document, document, document. The time records are so important, because if you get these types of cases where somebody's claiming that they're due unpaid overtime, if you don't have those records to refute that, it's really tough for your attorney to argue for you, the other side of saying that they're not owed this. So it was an interesting case. We ended up being able to come to a much lower settlement amount, but it was very frustrating for the employer, but it was a learning experience, and we have done an analysis of their workforce now, so.
My apologies. I have a question about off-hour communications by an employer. And being a municipal employee, I get frequent communications from select board members, town administrators, department heads. In the private sector, I would look at those as billable hours. But what are the thresholds? You know, if it's a 5-second response, or I have to do some digging and come up with a response that takes 30 minutes, or maybe I got to truck into the office on an off-hour day. Those are some, I guess, unresolved questions I have.
So obviously it would depend on, you know, an analysis of your entire job duties, so I can't give you exact legal advice on that. But if you are a non-exempt employee, anytime that you actually work, you need to be paid for. So you can document that. One of the important things as an employer, you want to have policies in place that says any time outside of your regularly scheduled work hours has to be approved in advance. So you have some employees who are like, well, I came in an hour early, so now I need overtime. Well, you weren't actually doing any work. You were just in the office having coffee or whatever it may be. You know, that doesn't qualify as overtime, so having that. But, you know, as an exempt employee, it's just kind of expected you work whenever work's needed to be done. As a non-exempt employee, you should be tracking those hours. So anytime you have to do anything, even if it's 5 minutes, that should be tracked because that is compensable time.
Is it a one-to-one, or is there like a minimum billable time, like 15 minutes increments or something?
No minimum. Yeah, I would say any work that you do outside your regularly scheduled hours, track it, and you should be paid for that. Yep.
So I have a question.
Yep.
So when it comes to exempt versus non-exempt, what role does the amount of agency somebody has over their position, hours, and things like that play in classifying somebody as exempt or non-exempt?
So the person is able to dictate their hours, and so if they have that level of control, then as long as they meet the other, qualifications, more often than not, someone like that is exempt. But obviously they'd have to meet the duties test and the salary basis and all of that. But, you know, and that's why it is too important of making sure in the beginning that the hours are clearly defined for employees, or that there's an expectation of you're gonna get 8 hours in today, and there's a method for tracking that, whether it be billable time or, you know, keeping track of like billable time of that, you know, I spent 10 minutes on this, I did that, you know, that's how I keep coming back to myself. But as an exempt employee, this is how I track my day, is my billable time to the clients of how much time I'm spending on things. So I could be working at 10 o'clock in the morning and take off 3 hours in the afternoon and be working at 10 o'clock at night, which happens more often than it should. But, you know, and that's okay, because that's, you know, I'm getting my hours in and I'm working, and that's kind of expected of, you know, kind of having that flexibility. So more in those situations where you have that kind of control, you're more likely higher up on the scale and may meet those other duties. But if you're not, and, you know, your employees have that type of control, then I would recommend making sure that there's a defined way and process for tracking those hours, even if there is that flexibility, to make sure that you're not missing any overtime hours that the person may be entitled to. That make sense? Answer your question?
Yep, thank
Okay.
Thank you. So in my operation, we pay by the job. So if you're a cameraman for an event, you get X amount of money, not by the hour. Is there a difference?
Are you as long as you're paying at least minimum wage? So if you pay, so we have a lot of people do, it could kind of be like a stipend type thing by the job, right?
We call it a stipend.
You call
yeah.
it a stipend, so
Yeah.
that's fine. So as long as what it breaks down to of however amount of time that they're on that job, and you break that down and it's more than the minimum wage, you're okay. But if it falls it under that minimum wage, you're not, you need to bump it up. So the minimum wage for Massachusetts is $15.
Right, and
Yeah.
so if you're, we'll say $25 to be a cameraman for an event and runs 3 hours, that's not right.
That's not right, yep.
Okay, thank you.
Yep.
Just had to write it down. So when you talked about some of the exempt standard, or the exempt tests, it says one of them was supervise 2 or more employees. Could that be part-timers and paid interns? What's kind of the 2 employee measure?
It doesn't, as long as you're controlling the work of at least 2 employees. So what their status is doesn't matter as much as your control and discretion over their job duties and their responsibilities, determining their schedule, things like that.
Correct.
So that's one of the criteria there. Cool. Okay. Any questions on that? So we've touched on some of these, but some of the most common mistakes that I see, obviously classifying all salaried employees as exempt is the biggest one. Classifying employees based on a job title. So, with that, supervising 2 or more employees, sometimes employers just think, oh, they're a supervisor or a manager, then they're exempt. We still have to meet those other duties, and the biggest one is having that independent discretion and judgment to be able to make significant business decisions, which often isn't met by just your regular manager or supervisor. Classifying employees as exempt based on occasional duties. So sometimes they make these decisions, or sometimes they supervise people. Remember, it has to be that 50% or more of their time has to be spent doing those duties. The other thing is failing to consider both state and federal law. As I said, Massachusetts generally mirrors the federal law, but it does have additional exemptions, so you do want to look at that. So tips for proper classification. You want to look at each employee and each position individually. So just because you may classify everyone at like the same level or the same job title, you really need to dig down and see what they actually do. A good starting place is the job description, but you also want to make sure that you really understand what their primary daily duties are. And don't forget to. You disconnected. Oh.
Sausage being made, excuse me.
I can keep going. And so don't forget to, make sure that you're considering that there may be other categories that they may be caught under. And it's really good. I know I'm an attorney. I'm going to say consult with an attorney. But it really is good to have that legal advice to make sure you're doing that in a thorough analysis and properly classifying them. Because like I said, a wage violation carries significant monetary penalties, which comes next. At stake. So wage claims for unpaid overtime, not only are they costly if you're found to have violated, but they're costly to defend and fight. You're going to have to hire an attorney. You're going to have to go through all of your records and all this. It is timely. And then if it gets to a litigation stage, that's going to cost more time and expense for you as well. As I mentioned before, without time records, their recollection of the hours that they worked or whatever records they may have is likely to prevail. So your motive doesn't matter. If it was a simple mistake, it stinks, but it doesn't matter. The court doesn't care. So unintentional violations, again, strictly liable. The court doesn't care. So really important to be mindful of this. Any questions on those classifications before we move on to the next sections? No? Okay. So independent contractor or employee, this is another major area that we see a lot of questions and issues on. So both federal and mass law presume that anyone performing work for an employer is an employee. It's the employer's obligation to prove otherwise, and there's different tests for determining whether a person qualifies as an independent contractor. So the federal law, it really looks at the degree of control and independence that the individual has over their business and their work. Massachusetts has this ABC test. And a written agreement is required. This is small writing, but I wanted to include everything in there for you. So it's important to see, what's the control and discretion they have over their work. Is there a written contract that we always highly recommend that you have a written contract that says this is not an employment relationship. You're not entitled to any benefits, and you have this discretion and control to control your business. Do they carry out their job duties with independence? Do they provide their own materials or tools? Do they use their own approach? Do they determine their own hours? And then a big part of it is outside the usual course of business. So their business should be different from what you typically do. It shouldn't be someone that it would be displacing, someone you would hire as an employee. Is it similar in nature to what you're doing, or is it something outside the scope? So, hiring an HVAC contractor to come in here, they would be an independent contractor. They have their own business, they have their own, they can have their discretion to determine all that stuff. They're not doing what you're doing. But if you brought a cameraman in as an independent contractor, probably should be an employee, because it's right there what you're doing, and you're probably determining the schedule and when they're working and what jobs they're doing. Questions on independent contractors and employees? No, that makes sense. Pretty straightforward. Volunteer or employee. So with most of you being nonprofits, you can have volunteers. They provide services for nonprofit or charitable organization. You really want to, there's considerations under both federal and state law about classifying someone as a volunteer. You obviously want to think of what your organization is. If it's nonprofit, you're good. Receipt of any benefits or expectations of benefits from the individual. Does the individual coming in and expecting to get something out of this, or are they sincerely volunteering their services? Whether the activity is less than a full-time occupation. And this is the most important one, is where the regular employees are displaced by the individual. So if you're bringing someone in to perform duties that, say an employee was there and left, and you're like, oh, we'll bring a volunteer in to help us with this stuff, they may not be able to be classified as a volunteer if that was the duties that an employee was doing. Whether services are offered freely without pressure or coercion, and whether they're typically associated with volunteer work.
So when it comes to us municipal people, which are there are a few of us here, what does a volunteer mean when it comes to municipal government? Do we have to provide payment, or what rules are that? Or are we just a very, very, very special nonprofit organization?
Yeah, very special, very special.
Thank you.
No, similar analysis of that, with the municipalities, the same thing, but to look at that analysis of making sure that they're not displacing someone who could be an employee. So the municipalities also come in to play for that.
So tread lightly.
Yep.
Okay.
Yeah.
So one of the things we had at BevCam was we were having kids come and help cover the game, and then the staff started providing them with gift cards to Amazon as compensation for it. And I said, it sounds like we're actually compensating them. I just didn't know if you had. You've been so good at anticipating everything.
You've made my presentation, Rob.
Jackie's trying to say, is that all out the issues that Rob is?
So question in terms of another municipality. The lifeblood of most of our organizations, whether it's a library, a public access television station, the recreation department, is mostly volunteers. However, each one of these departments has a very small but professional staff, and quite frequently, the part-timer, which is usually only one in every one of these offices, is almost the identical responsibilities of the volunteers. The only difference is the volunteer hours fluctuate on days and times, and the part-timer is consistent. So in terms of a municipality, those aren't our decisions. Those are top down from elected officials. Where does that leave us?
Yeah. They're on the hook, not you. That's a difficult one of having, if they're performing the same duties. But if the thing that they may be classified as, which we'll get to, is maybe like trainees or interns. Are they maybe getting any educational benefit from doing this work, or is it just?
I would say in the early stages, yes, but some volunteers go back as far as 20 years. So how much more can you teach them?
Yeah. So that's probably questionable. They should probably be being paid. Because if they weren't performing those duties, someone else's would have been. So that's probably a misclassification.
So if we bring quote unquote volunteer, they should really be either an intern, paid intern, because we have an intern program that school actually pays them, or do like a senior work off. Is that how we should do volunteers?
Yep, or just have them, make sure that their hours are very, limited, that they're not doing like significant duties. But I think going towards come back to this one, internships, this is the whole, usually interns who are receiving like school credit or anything like that don't have to be paid, but if they're not, they do have to be paid. But maybe in your instance, you can have them as like a trainee type of thing, not the ones that have been there for 20 years, but you may be able to have like this internship trainee program, and then this is kind of the test that goes with it. It's a primary beneficiary, so the individual themselves has to be the one that's benefiting from this work arrangement and not the organization.
So what about the local producer who wants to come in and make their own show? Are they a volunteer at that rate, or are they just someone from the community wanting to make a show?
Yeah, that would just, I think someone from the community, that wouldn't be, that's what I was gonna say. I don't know how you refer to a client or customer, Because the same thing, if you have someone come on, you have a regular show that you have, covering local sports or whatever, and someone from one of the coaches comes on, you're not gonna pay them. They're not gonna be classified as a worker, they're just a guest.
Right.
But someone who facilitates that program week after week after week, that's different.
That may become an employee.
It just got much more difficult today.
Guys are making me sweat up here, my God. All these cities and towns are doing all these crazy things. I guess you would have to look again at, what kind of discretion do they have in controlling that show? They come in with just the idea of it and then host it, or are they controlling when when the program is, what the content is?
Because people can come into our stations and borrow equipment.
Facilitate pretty much top to bottom.
Yeah, and that's the whole premise of us, pretty much.
Does any aspect come under free speech that would exempt that? Because this is their outlet to that.
Yeah.
It's very complicated.
Yeah.
I'm sorry, guys, I made things complicated.
I feel like, but they're not, I don't think they fall into any of either an employee or a volunteer.
We've often gotten the discussion as to whether it's a webcam production or if it's just somebody's
Yeah.
who's coming in to produce their own show.
Yeah.
If it's like we're doing municipal meetings and something that we are in charge of the production of it,
Yeah.
then it would be our production and they would be employees. But if somebody's coming in as a public access producer client, that would be the differentiation.
Yes, yeah.
It's just who's sort of responsible for the production.
Yes.
Yeah,
Yeah.
if that helps.
Yeah, no, and I think that's what you said it more eloquently than I said. That's what I was trying to get of if they're coming in and they have the control over the stuff, then it's,
Right.
separate than if, the station itself is saying, oh, this is what we're gonna do. Let's hire Joe to come in and do this. Or
And
let's bring this,
It gets very difficult. I've had public access producers say, can I get paid for this because I'm putting all this time into it?
Mm-hmm.
And you're getting the benefit of the show and, but we have to be very distinct
have
about
to,
what that line is. So.
Mm-hmm.
I promise my last question. If we pivot a little and look at like a Parks and Rec department, and you have a volunteer coach, there are certain requirements they have to go through. They have to be Corey checked. They have to be a certain certification. But they dictate the day of the practice. They dictate the length of practice. They dictate the drills in practice. They dictate who plays when, where, why, and how. They're in all the decision-making places, and they're putting in significant time that maybe many people wouldn't even be qualified for, and there were certain bars that they had to meet. Would that not put them in a non-exempt classification for compensation?
So if they're working for the so if it's
Whether it's
through the town or through, the rec department.
I mean, and this is not a new thing, but it's something that's been going on for, probably a century in our country, and it's not it's universal to every facet of the country, but I think that the criteria is extremely helpful, but when I start looking at that in some of the other capacities that me and other community members use, I kind of see that we all kind of fall into there.
Yeah.
And so I thought I had a pretty good grasp, but now I'm getting more confused.
Oh, that's not what I want. The thing is, so when you have like a volunteer for a sports team, it's, typically they are choosing to do that. If you're going out and like recruiting for a coach, then you're hiring them on. So like your high school coaches should be paid. They're employees. But, for your rec teams and things like that, more often than not, they're like parents or family members or something, and they're volunteering their time. And yes, the league is getting the benefit of that, but it's something that they're doing freely. And even though they put significant time into it, they're, doing it on their own fruition, if that makes sense. Of, like, you're not requiring them to do it. So it's kind of like a sign-ups to volunteer. Even though they're putting significant time in it, they're, again, not working like on behalf of, the organization.
Well, couldn't they do something that would bring in litigation to the organization?
It would be them personally. So the organization would be on the hook if you didn't take those steps of doing, Mass law requires query checks on any volunteer working with children. So that's like, those are requirements at the organization. So the liability would be on the organization if they hadn't run, that query check, they should have known about something and something happened. But the volunteer would be personally liable. So with the wage and hour stuff, it gets into, really looking at, are they eligible for compensation in employee benefits and what's offered in that sense? So, your volunteer that's coming in and working, coaching a soccer team after their regular job isn't going to be eligible, get benefits in workers' comp and things like that. They're not going to be eligible for that. Because it's still, even though they're putting in a significant amount of time, it's still a part-time position. Seasonal in nature often. We can talk more about this after, because I think we're getting a little bit off of the wage and hour. WCTV, this has never come up with anyone, so they have volunteers attend and record all the high school football games during the fall season. For each game attended, WCTV provides the volunteer with a $25 gift card. Anna attended 3 games on Saturday and received $75 in gift cards. What are our issues with that? Lots. So state and federal law allow, payment or reimbursement to volunteers in very limited circumstances. So out-of-pocket expenses, reasonable benefits if they're, again, reasonable benefits for the organization, or a nominal fee for their services. So these nominal fees may not substitute for compensation or be tied to productivity or hours worked. So the issue was like each game she got this set amount. So the more games she worked, the more she got. So then you kind of lose that volunteer classification and would have to be considered an employee. The difference would be, maybe at the end of the month, there was like a thank you gift, here you go. We appreciate you helping us out when we needed one card. It's not tied to the productivity and the hours that they worked. I haven't been watching time at all, so I'm good, okay. Employees as volunteers, this is another area that gets a little tricky. So any time spent where someone's classifying as volunteering during their normal working hours is actually working time and has to be compensated. If it's outside their normal working hours, they may volunteer in support of outside charities, so sponsored by the employer. So if you're working with, another charity or having them come in and do something that's outside that employee's normal working hours, they can volunteer their time for that and don't have to be paid. If it's, a part of their usual activities, it's okay if it's different from their duties that they normally perform. So it's still part of the employer's business. If it's outside of the scope of what their position is, they can volunteer to help in that area, just as long as it's voluntary. There's no coercion or pressure. We talked about kind of these internships. So the biggest thing is the misclassification with these, with independent contractors, volunteers, and internships. There's civil liability. So you could have an IRS audit and penalties for not paying taxes. You may be required to pay back taxes, back wages. These individuals may have been eligible for benefits under your benefit plans that you would have to make retroactive, vacation, 401k, sick time, other, state leave laws that you may need, workers' compensation, liability damages. You may be subject to attorney's fees. And there's either criminal liability, so criminal fines, felony imprisonment. That's a little bit further down the line. It really has to be bad, but there's significant risks with misclassifying employees.
Just really quick, everybody, the parking meter ticket guys are going by right now, so please take a second and check your meter or your app, wherever you paid. FYI.
So employing minors. So both federal and state law control, when, where, and how long minors can work. So minor obviously is anyone under 18 years old. Massachusetts requirements, you're required to have a work permit on file, and there needs to be one with the local superintendent's office. Children under 14 may not work, except in very limited cases, and then that's just like babysitting and newspaper delivery. Minors may not work past 8 p.m. without direct on-site adult supervision, and they may not work in certain occupations or perform certain dangerous duties. Going through that list, I don't think your line of work has these very dangerous, duties that they outline. Like, I don't think you're working with heavy machinery, but if you're, on-site filming something that may be heavy machinery, make sure that that minor's not in the mix of it. So a school committee meeting. Harry is 15 years old and works after school at Hogwarts Community Access. Harry has been a great help around the office and has offered the opportunity to assist Ron at the local school committee meeting, which will be broadcasted live on Thursday. The meeting starts at 5 p.m. and is scheduled to run for at least 3.5 hours. What, if any, issues do you see with this? I haven't given you the answers to these yet, so. I think the 3 out. Yeah. Are we saying 3? Yeah.
But there is adult supervision in theory.
Mm-hmm. Yep. So Harry's 15, so we'll skip down to the 15-year-old. So Harry can't work after 7 p.m. So the meeting's going to go after 7. And the tricky part, I didn't put whether it was during the school year or not, but if it was during the school year, you can't work any more than 3 hours on a school day. If it was, which more likely than not, school committee meetings in session during the school year. So work restrictions too for 16 and 17-year-olds. They can't work at night from 10 p.m. to 6 a.m., more than 9 hours per day, 48 hours per week, or 6 days per week. And then additional, the 14 and 15-year-olds at night from 7 p.m. to 7 a.m. They may work until 9 during the summer. During the school year, it's very limited. They can't work more than 3 hours on any school day, 18 hours during any week, 8 hours on any weekend or holiday. And when school is not in session, they can't work more than 40 hours per week, 8 hours on any day, or 6 days per week. So make sure that we're watching with our minors of how many hours they're actually working and the hours that they are there. If they're a minor, you can't have, even if they're volunteering, the hours would still apply. It's all right, no one needs to know. I didn't hear it. So, I know, right? Let's cut that part of the recording. Just kidding. So Massachusetts hours worked. So the most important thing, we have to pay our employees for all their hours worked. So what is hours worked? Hours work, is working time. So that's whenever the employee is required to be either at the station or on duty at another location. Even if they include, it includes any time worked before or after shift to complete the work. The big thing is, we recommend that employers say, all overtime has to be authorized in advance. But the thing is, if someone does work unauthorized overtime, you still have to pay it. You can discipline them for it, though. So that's a tough one that for people to grasp sometimes is you still have to pay that overtime, but it can be a disciplinary matter. So that's something of thinking about giving them a verbal warning, or if it's something that they consistently do, a written warning, or even, if it's all the time, it could lead to termination, but we still have to pay them for that time. If an employee takes a break, if it's 20 minutes or less, that has to be paid. And then if they travel during the workday, so if they're going to different locations or different events, that travel time counts as hours worked, but it doesn't count for their regular commute to and from the station. Reporting pay for-profit employers, so this doesn't apply to my nonprofits, must be paid at least a minimum of 3 hours. If they're scheduled to work for 3 or more hours, report to work on time, and is sent home after working less than 3 hours. I think this applies to them. It does? Yeah. Okay. And then on-call time is compensable, so they have to be paid unless they're not required to be at the work site and can use their time freely. You can have reasonable restrictions with that, like no alcohol or close in the vicinity to the area. But if they're required to be at the work site and just be kind of on-call, then that time has to be paid. Meal breaks, so employees are entitled to at least 30-minute meal break for every 6 hours worked. They must be relieved of all duties, free to leave the workplace. For non-exempt employees, this can be unpaid. For exempt, it will be paid because it's just part of their normal salary. And employers may require employees to take their meal break. So sometimes we have employees that are like, well, I'm going to skip my meal break and get that half hour of overtime, or I'm going to leave a half hour early. You can tell them that you can't do that. You're required to take your meal break. If you're giving up, it's on your own, but you don't get to take that extra time. Vacation time, paid vacation time is not required under federal or state law, but if you offer it, what your policy says will be enforced. So in Massachusetts, vacation time earned under any policy is considered wages and must be paid out upon termination. Other states don't require this, but if you have it in the policy saying that it won't be paid out upon termination, then that will follow. But Massachusetts, we do have to pay it. Deductions from wages. So you can there are permissible deductions, any of those required by law, whether that's state and federal income taxes, Social Security, unemployment. The Mass Paid Family and Medical Leave employee contributions can be deducted, and anything that's voluntarily authorized by the employee, such as group benefits like health insurance, things like that. Any voluntarily authorized benefits have to have written authorization. So you have to have your employee sign something that says they authorize that deduction. You can't deduct from, and full day absences for exempt employees. So there's strict rules on when you can deduct from an exempt employee's pay. Generally, you have to pay them their weekly salary, even if they do like 5 minutes of work during the week, they still have to get it. But if there's a full day absence that, they've used all their sick time that's available and they have to be out sick for a full day and they don't complete any work, you can deduct that full day from their pay. Impermissible deductions to cover your own, business expenses or lost equipment. You can't deduct that. One of the things we do recommend having is if you're giving employees equipment, having them sign something that says, I'm responsible for this equipment, keeping it in good repair, and I understand that I may be responsible for paying for this if it's lost or damaged. So, but again, has to be in writing for you to be able to take that money from their check. Doesn't really apply to you, but housing, meals, and uniforms, there's limits on when and how much can be deducted. It's generally that you just can't take their pay rate under the minimum wage. So a real case a few years ago, Beth was terminated from her position as a custodian for the city of Methuen. At the time of her termination, she had accrued unused vacation time in the amount of almost $9,000. The city of Methuen paid her this amount 3 weeks after her termination date, plus a trebling of interest on the delayed payment in the amount of $185. Beth sued the city of Methuen for the violation of the Mass Wage Act for failure to pay vacation pay on the date of termination. How did the court decide? Any ideas? She did. Court held that an employer who fails to pay an employee who is voluntarily terminated all wage payments due on the date of termination, again, strictly liable for liquidated damages equal to treble the amount of wage payments. So what happened was the argument from the city of Methuen was, well, we still paid her. We just paid her 3 weeks late, and then we paid her, treble the interest from that time. Well, the court found that wasn't the proper remedy. They had to pay her that vacation time on that date of termination with her final wages. So the city of Methuen was ordered to pay approximately $27,000 for this unpaid vacation time, and she was also awarded fees and cost.
This exact scenario happened to both of us. So we were paid out, though, on the next pay date, not the date we were terminated. So if we were terminated, really?
If you're terminated, yeah, look, how long ago was it? You guys want to talk later? I'm just kidding.
New edition.
I'm just kidding. So if there's a statute of limitations. I think it's 3 years. Did you guys? Yeah, did we just missing it? But so, if you terminate, and if an employee is terminated, they have to be paid on their final day of employment. If they resign, then they can be paid on the next regular pay day. So with that termination date, it's very, very important to have that vacation time as well, because this law is saying that it doesn't matter, okay, yeah, you paid it a few weeks late and you're saying this is okay, we paid them interest. That doesn't matter, you still paid it late. So as employers, if you're terminating an employee, make sure that you have like all your ducks in a row, that you're ready to pay them that final pay, you're ready to pay them any accrued vacation time that they may have still available. Otherwise, if that's not something, then you need to something comes up that someone needs to get out right away, consider suspending them and then terminate them at that time that you're ready to pay them all those final wages, because it can be very expensive. Yep, go ahead.
Can I ask you an unrelated question?
Sure.
Regarding jury duty? Mm-hmm. So in my scenario, I was on a case for 8 days, and the town required me to pay them or to reimburse them the money that I received from the feds for being on that case, in addition to my parking stipend that I was given for parking in the court garage. So I had to pay all that back to the town of Shrewsbury.
Did they pay you for
They
being
did pay
out?
me. They did pay me out. So I understand that, but I guess it's the parking one that still rubs me the wrong way.
That seems strange.
They were claiming that you can't make any additional money because you were being paid to be there. And I was like, well, it wasn't additional. All right, never mind. So
No,
theoretically, they
yeah.
should not have done that, correct?
I don't think so, no.
Okay.
It shouldn't have been, yeah. So Massachusetts law, your employer is required to pay for 3 days of jury duty. So that by them paying the full time was more generous, and they can require, usually what they would do would be pay the difference between what you receive from the state to make you whole. So what it sounds like is they made you whole and then just required you to give them what you got from the state. The parking piece of it is a little strange, though. They're really getting you for every dime. These. Okay. Payment of wages. So Again, make sure that you paying for all hours worked, overtime worked, and any promised holidays or vacation time. Must be paid 6 days after a pay period ends. So pay is required to be on either a weekly or bi-weekly basis. Salary exempt employees may be paid less frequently. Again, very important, I put it twice. Final pay must be paid in full on the next regular payday if employee resigns, last day of work if employee fired or laid off. It must include all accrued and unused vacation time. Wages must be paid by cash, check, or electronic direct deposit. And with each payment of wages, you're required to provide a pay statement. And it has to outline name of employer, name of employee, date, number of hours worked, hourly rate, and amount, and the type of deductions. Also make sure you're including, any overtime hours worked in that rate and any, sick vacation or holiday pay that they got. Notice and record keeping requirements everyone should have in the workplace, the Mass Wage and Hour Laws workplace poster and the FLSA minimum wage poster, along with a number of other posters that are required by the other laws, but I'm focusing on wage and hour. Record keeping, you should have personnel files on everybody, which includes this information. This is required by Mass law of having their name, address, social security number, and job title. Also, make sure that you're tracking their wage records. So what's their rate of pay and salary as they get increases, that should be updated. Amount paid each pay period, any deductions, any fees or amounts charged, hours worked each day, dates worked each week, and paid and unpaid time off. Payroll records must be kept for 3 years. Personnel records, Massachusetts has personnel file law that requires if an employee requests to see their personnel file, you have to provide it to them within 5 days. And provide it means either let them review it during regular business hours with a business representative there, or making a copy and giving it to them. You also have to keep those for the duration of the person's employment plus an additional 3 years. Mass earned sick time, don't want to dive too far in because we've limited time and all these things are a lot. But mass earned sick time, you're required to provide sick time, whether it's paid or unpaid, depends on how many employees you have. If it's under 11, it's unpaid. If it's over 11, then it has to be paid, and you have to provide them at least 40 hours per year. So you're required to track the accrual and use of that. So whether you provide it as a lump sum at the beginning of the year or they accrue it throughout the year, make sure that that's being tracked and that as they're using it. And that's important too of, like I said with the exempt employees, if they exhaust all their sick time and are out one day, you can deduct that full amount, but it's important to have that tracking method done. Mass paid family and medical leave, this provides paid family and medical leave for the employee's own serious health condition, a family member's serious health condition, reasons to do birth, pregnancy, and qualifying exigencies. It's similar to the FMLA, but with the exception of that, it is paid. So you're required to track wages, the contributions that you can take from employees' pay, and then the employer portions, and then the use of their time. So it's really important to have this because as employers, if you're in the state-run plan, you're required to submit quarterly reports to the state with this information. And then you'll also be contacted by the Department of Paid Family Medical Leave if one of your employees does file a claim for benefits and leave under this law, and they'll ask you for all of this information, so it's important to have. So wage and hour updates. This year, as I mentioned, the minimum wage was increased to $15. There's no increase in 2024, so you don't have to worry about that. The premium pay mandate, the blue laws, were eliminated, so no Sunday holiday premium pay. It's not required anymore. Effective January 1st of 2024, there are updated PFML contribution rates. There's a pending pay range transparency bill, and at the federal level, there's that proposed overtime rule. So on January 1st, the contribution rate will increase If you have 24 or more covered individuals, it will go up to 0.88%. If you have less than 25, it will increase to 0.46%. So something to be mindful of and talk to your payroll companies about, and also make sure that you're distributing the notice with the updated contribution rate so employees are informed of what will be deducted from their pay. And also, not that this matters to you, but the weekly benefit amount did increase as well. So it's up to $1,144.90, which will be paid by the state if you're in the state-run plan. On the horizon is the Massachusetts pay range transparency bill. Very likely that this will get passed because there is a trend of these going, being passed at the state level. Colorado, California, New York, they all have them already, shockingly. They're the ones that started it. But, excuse me. So it's getting much more out there of having the pay and the salary out. So what this would require is putting the wage range in any job postings and disclosing it if asked. So they're trying to make, obviously, things more transparent with employees than having this, known secrecy of you don't talk about wages that's going away. And they also want to narrow the pay disparity between not only gender, but demographic groups. So there have been studies that have shown that a man is much more likely to negotiate a salary than a woman is. So what was happening, there was this huge pay gap between genders because they would just say, "Oh, what were you paid at your last job? Okay, this is what we'll pay you." And someone else would come in and say, "No, this is how much I demand." So finally, things are going that we're getting kind of equal, and this will try to get it a little bit more for everybody. So it's very clear what's out there. So it does apply to employers with 15 or more. So you'll have to put them on the job postings or advertisements, and whenever you have a promotion or transfer to a new position, you have to tell your current employees the pay range. It's defined as an annual salary range, hourly wage range, or other compensation that the employer reasonably in good faith expects to pay for such position at that time. Other compensation does include additional benefits and stuff, so when these this is just in the proposal stage, but if this does get passed, there will likely be regulations that will define this even further. The range may not be unrealistically wide, so you can't say, "Oh, we could pay $5 to $100,000 for this position." It really needs, but it can be wide of saying, this position generally pays 45 to 75, depending on experience and education, things like that. You can base it still on the merits of a person and their skills. And it doesn't have to be the exact, but it should be pretty close. So preparing for this, because like I said, it's likely to be imposed. They're kind of pushing it along. Audit your current pay practices and consider whether any adjustments are appropriate. I've dealt with clients in other states who have, struggled with this, of really taking an analysis of how much they're paying who, and do we have to change anyone's, salary to make it more consistent across the board. What are your standard responses? What are going to be your pay scales? Figure out what the wage ranges are for each position. And that will really make you really take a look at the job duties and expectations and responsibilities for that position rather than looking at the individual. Then you can alter it based on the skills and level of expertise.
So let's say we have an employer that has two positions, same positions, going to be offered to two different people, and they obviously want to stay within the same compensation to the two employees. But the benefits that are offered to each are different. So maybe one gets 1 week's vacation and one gets 3 weeks vacation, and one gets a stipend and one doesn't get a stipend. Would that come into any of the equation in terms of equitability for
Yep.
same work, same
Yeah, so it needs to be like same work, same responsibilities, same job duties, but then also looking at seniority, skills, education, merit. There are still things that you can look at to say, okay, this person has been here for 10 years. They're going to get 2 weeks vacation. This person's only been here for 4. They get 1 week. So there still can be differences, even if they perform the same job, based on their seniority, their experience, things like that. But same level of experience, same level of education, same exact job duties should probably be paid the exact same and offered those same benefits. Okay? Make sure that all your managers are aware, if this gets passed, of the fact that you can't take any adverse action against employees for discussing their wages. There's also the National Labor Relations Act, which protects concerted activity, and that's employers discussing their wages, discussing workplace concerns, safety hazards. That's another big one that comes into this, that there has to be pay transparency, and you can't discipline someone for talking about that. So just make sure everyone's on that level, and be prepared for difficult conversation with the employees. This may come up of seeing how someone that you think is, on the same level as you may be paying more or less, and once these once these salaries start being released, the questions may be asked by employees. The proposed updates to the federal overtime rule. So they just released the proposed rule in August, and it's going through the rulemaking process, so it's open for comments right now, and then it will have to be reviewed again for all the comments, and then they'll fix it, and then other things, but they're going to push this through. They tried to do this before under the Biden administration. The DOL proposed a significant increase. It did get shut down, and then they were able to increase it from like 400 and something to the 684. Now they're pushing for a little bit more of a jump to that 1,059. The DOL said if this is approved, 3.6 million more employees will be entitled to overtime. So what this is going to open up is you're going to have more non-exempt employees. You may have more non-exempt employees because they may not meet that salary threshold. So that's what they're doing. It will also increase the highly compensated employee exemption total compensation requirement to 143. Not that anyone cares, but it restores overtime protections for employees working in the U.S. territories. And a big thing will be that it will implement automatic updates to the salary level test thresholds every 3 years to reflect the current earnings data. So what they looked at to see what's the median income across the board, where should we be, and they're upping that to make sure that it's more people are access to get paid more. So action items, confirm your proper classifications, look at your exempt, non-exempt employees, your independent contractors, volunteers, interns. Are they being classified correctly? Are they being paid correctly? Review your vacation and paid time off policies, make sure they're clear on when and how that time can be used and whether it's paid or unpaid. Ensure your proper notice posting requirements. Review these arrangements, conduct a wage and hour and pay equity audit, look at how much you're paying jobs. Is there a substantial business reason behind those wages or any differences? Prepare for that pay transparency requirements and prepare for the overtime rule. And that's it. Any other questions?
Do I? Yeah, there we go. So, how long should you hold on to timesheets? Like, for example, I have timesheets from high school interns that have now graduated college. So,
3 years after their termination, separation from employment.
In regards to the pay transparency, does it have to be a range? Can it be an exact salary?
It can be an exact salary if you know it, but all it requires right now is a pay range.
So going off of that too, so say you have 3 people that are in the same level of the organizational chart. If one of them comes to you and says, about another person's position, like what's the salary? Do you have to give them that person's exact salary as of now, or the range when it was posted? What are we?
No, so that's a good point. I'm glad you brought that up. So as the person, anyone in an HR role, or if you're the one that controls everyone's salary, there's an exception that you don't have to tell someone else's salary. So if you control the salaries, you don't have to tell it. So if someone comes to you and says, how much does this person make? You don't have to disclose that. The big thing is if that position's open, they may see that position open. It actually happened, to a client, and they're like, we posted a job, and then our employee came to us because she saw how much with the wage and was very upset because it's more than what she's making, and how do we handle this? So that's going to be where you're going to see those issues. And you can't prohibit employees from discussing amongst each other. So if they were to talk to each other and say, oh, well, how much are you making? And if they want to disclose it, they can. But as the person who either determines or controls the payroll records and the salaries, you don't have to disclose that, and you shouldn't.
And the last question I had was PFML. So say you have an employee that lives in another state, how do you handle PFML?
If the majority of if they're expected to work in Massachusetts, they'll qualify.
Okay.
Well, and so there's there's a
So
whole.
I'll just give you, I
Yep.
have an employee whose wife is due later this year, or early next year. He lives around but works in Massachusetts. How do we handle the PFML?
Eligible for it.
Eligible for it?
Yeah.
So I'll take the job. Yep.
So what I'm wondering is if you're suggesting that because an employee has been there for 5 or 10 years and started at a base salary, and we're hiring a new employee, and because salaries have increased, do we have to make up the difference between the old employee, if you will, and the new employee? Because to get the new employee, I need to pay $100,000 versus the $75,000 the old employee has been earning all these years.
So it is something that you have to, kind of take into consideration what you're paying your current employees, and obviously, now people are asking for a lot more money than they were even 5 years ago. So it is something to take into consideration of looking, what are we paying for, other people? It doesn't mean that it has to be the exact amount for it. You may, obviously if someone comes in and tries and negotiates another salary, or that you need to increase it to appeal more people, that's okay, but you may want to consider whether it be appropriate to bump someone else up. If someone has more experience, or higher education levels or greater skills than the individual that's been working there, then you can justify giving them a higher salary. So you want to look at the business reasons in the individual themselves, and where are those differences that would justify that pay difference.
But there'll still be some sort of disgruntledness, I'm sure, between the two.
There may be, and that's what's unfortunate, and that's why kind of. Not legal advice, but taking the morale of your staff of, is this someone who's valued? Would it benefit us, or would it, to increase their salary a little bit to make them happy and feel supported? Or do we want to risk losing them because they're mad someone's coming in at a higher rate than them?
Or maybe they should apply for the new job.
True. Yeah, exactly.
Okay, thank you.
Yeah, you're welcome. Any other questions or concerns? I'll be hanging out for a little bit, so if you guys want to catch me on the side, you can. Also, my email's here. Feel free to reach out to me. We have some Instagram and Twitter stuff, although that needs to be changed. It's X now, isn't it? Something different? I don't know. But feel free to reach out anytime, any questions, concerns that you guys may have. I do, and we have folders out front that again has my business card in there and information, contact information, as well as copies of the slides and some information about our firm. So thank you so much for having me. You guys were a great group. I really appreciate it.